We can argue for alternative visions of property, and we should, but that doesn't mean that they're actually going to be successful. So to think of something, a performance as felicitous, is to think of it as successful. Hernando de Soto's very narrow understanding of land titling is successful not because it's right, but because it aligns with other performances, what you might call assemblages of property. It plugs very neatly into the operating system of capitalism, racial capitalism, and the incentives that are associated with it.
When I was a graduate student, I was interviewing smallholder farmers near Salinas, California, asking them about what was stopping them from using more ecologically sensitive agricultural practices. One of the farmers stopped me and said, "The problem isn't how to farm. I know how to do that. The problem is I can't find any land to farm." This one comment changed the course of my research career. First of all, obviously the farmer was correct. If a farmer doesn't have secure land tenure, what's the point of them slowly building that place-based ecological knowledge that I was so interested in? Farming on a month-to-month lease meant farming to make rent, not to produce food. It makes you wonder who's going to plant a tree if they're evicted before they have a chance of seeing it mature. I began to see how concerns over sustainable food were really undergirded by issues of land access and control, of property, propriety, and the mythical power of ownership. And I wasn't a lawyer. I had studied the wrong discipline. It became so clear to me that opening space for that farmer in Salinas to practice sustainable growing practices would require changes to tenant protections, limits to land financialization, fiercer restrictions on the power of landlords, expansion of public agricultural lands, redistribution in exchange for food production. All of this requires legal activism, or at least legal innovation. We need the law for transformation. But appeals to the law, such as the one I was just calling for, makes a crucial mistake. Seeing the law as something that is fixed or natural, separate from the realm of the social, reifies its power. The law isn't manna from heaven, it's a clever social construction that provides consistency and security for social and environmental interaction, made to freeze in place a set of rules and ways of living that people work out through customs formed living on the land. So the law strongly shapes how landscapes look, work, and feel. But it is also true that landscapes create the law. And therefore, appealing to pure legal innovation to create new emancipatory landscapes for agriculture or anything else is not enough, and even perpetuates a blind spot of the law's propensity to maintain the status quo. At least this is the core insight of the niche field of legal geography, a quasi-discipline or conceptual project that tries to understand the unique relationship between space and law. From my vantage point, legal geography gives us a tool to see how the law actually works, which of course teases a recipe for how to change it, beyond the limits of just doctrinal pencil pushing. Reforming property for sustainability demands such an approach. One of the tenets of legal geography is that lawyers with a humility towards their craft and geographers with respect for the law's centrality ought to work together to do transformative work. So for this episode, you'll hear Frankie McCarthy, a professor of private law at Glasgow University, interview Nick Blomley. Nick Blomley has been central in the development of legal geography, and you'll hear Frankie tease out some of its core concepts while working through this issue of the way dominant notions of property get made, and of course, hopefully, unmade. I'm Adam Kahlo, and you're listening to Landscapes. Here's Frankie McCarthy and Nick Blomley.
Well, thanks, Nick. Welcome to the podcast.
Thanks, Frankie. It's lovely to be here.
My research is in property law. That's my background. I'm interested in property law, especially land law in Scotland. And it always fascinates me to learn how property concepts are dealt with in other perspectives from other disciplines, which is how I came to read your work in the first place. So I was interested in this article you published in 2005, where you asked readers, just right there in the title of the article, to remember property. Now that maybe suggests that we've forgotten property, right? That's the implication in the title.
Mhm.
So why is it that you thought it was important for us to remember property, and what is the danger of forgetting it?
The article was an editorial written for a geography journal. Property scholars have not forgotten property. It was written broadly for a social science or human geography audience, the sort of audience that I sometimes speak to. And I wanted to speak to them, to ask them to remember property. And in so doing, what I was trying to do was to ask them to remember a couple of things. Most importantly, to remember or to re-engage with property in its richest sense. My sense is that non-lawyers tend to have a very narrow understanding of property. Sometimes, I'm afraid, some lawyers have a rather narrow understanding of property. I like to think of property as a state-sanctioned set of enforceable relations between humans and non-humans that governs rights to use and benefit of vital social resources, resources that are fundamental for life in its richest sense. Property makes certain worlds possible and others less possible. Property is not something that's given, but is conditional, it's historical, it's deeply political. And so I was trying to kind of put property back on the scholarly agenda in that sense. But in so doing, what I was trying to do in that piece was to remind scholars that we used to actually have a much more kind of lively conversation, an ethical conversation, a political conversation about what property is, what property could be. If you go back 100 years, 200 years, at least in the kind of the Western canon, scholars like John Locke or Proudhon, the French anarchist, or Marx, fighting about what property is, what property could be. So Locke, of course, has a very powerful story about the privatization of property. Property is understood to be really about private property. That's good. That's the way things should be. And then Marx comes along and says, no, the story of property is a story of violence, of blood and fire, as he puts it. We need to recognize the social dimensions of property. Then we have other scholars who take property in a different way. But the temptation now, at least in as I felt it back in 2005, was that we've forgotten that politics. We've forgotten the importance of property and the way property shapes our world. But property really hasn't forgotten us. It shapes our world in fundamental and important senses.
You touched there on this idea that we used to argue about what property is. It wasn't just accepted that there was one version of property and that was all there ever could be. So, in that same 2005 piece, you wrote about that. So, you said that property used to be a commodious category that included related ideas of propriety. It acknowledged a complex array of estates and interest and enrolled a rich dramatis personae ranging from Locke's yeoman farmer to Proudhon's murderous landlord. So I love that idea of the richness that we used to have when we talked about property, and maybe that's been lost. But what would you say now is the dominant model of property, and how has that come to replace this more contested understanding that we used to have?
Before I get into that, I just want to maybe qualify the we in the 2005 article, the audience, the implied audience that I think was in that article, which I think sometimes we as scholars fail to fully, or I've certainly failed to fully acknowledge. And I was referring in that we to broadly the kind of the Western canon. And I would want to qualify that by saying that in many other parts of the world, of course, we haven't forgotten property. And in many other contexts, we or others have not forgotten property. If one thinks, for example, about indigenous land struggles, there's long been a profound and very important understanding of exactly what property is and what property should be. So I just wanted to qualify that because I think that's important. And when we think about, and this is, I think, a broader point that I think is important in thinking about what property is or what property could be or how certain models of property have become entrenched, I need to be cautious in recognizing the diversity, in fact, of property on the ground, that property can take many forms, both actually in formal practice, if we think about legal doctrine, but also in terms of political conversations and struggles in the global south, for example. So that's just by way of a bit of a proviso. But that said, I think it is important to recognize that, yes, we used to think of property, we in the sense of people in the sort of the Anglosphere, people in, say, the common law world, if that's our focus for now. And so you can certainly find people, including Locke, talking about property actually in a very commodious and broad sense. It's not just about rights to land, but also the interest that people might have in other forms of property and notions of propriety, which take us beyond the idea of simply property in land, but include social obligations, broadly speaking, associated with rights to land. But I think that said, it is quite clear that a much narrower understanding of property dominates, a much smaller, if you will, understanding of property dominates. And put simply, that centers private property, and property is not just private property. Property can take many forms, including state property, common property, but private property has become the default in thinking about property more generally. And private property then becomes understood in, again, a much narrower sense. Some have described this as the ownership model or the Blackstonian model, which actually misreads what Blackstone actually said about property, but that's an aside.
I think that's always the great joke, is that even Blackstone didn't ascribe to the Blackstonian model of property.
No, that's right. But that gets us to questions of what property actually is, which we can maybe talk about later. Yeah, which is an interesting point. But broadly, we're talking about something I suspect that most listeners will be familiar with, the idea that property is private property, that private property is basically a simple relationship between a single owner and his land, and it tends to be gendered. It tends to be implicitly racialized, that we're talking about white people, forms of white privilege in relation to that relationship. And then if you have a relationship to your land that's private, then basically you have the trump card when it comes to defining how that land should be used. And that's not just an analytical characterization, it's also a normative, a prescriptive characterization. That's the way things should be. And then that smuggles in all sorts of understandings about how private property creates appropriate incentives, which facilitate forms of beneficial improvement and use to the land and so forth.
Yeah, so I think when you talk there about the fact that this dominant idea of property now is inherently gendered, it's inherently racialized, it sort of answers the question itself of how that model of property came to be the dominant model. Because, like anything else, systems of power use whatever mechanisms they can to re-entrench their power. In this situation, property, or this concept of property, and particularly the legal dimension of property, is one of the tools that systems of power have used and continue to use to make sure that they stay in that powerful position.
You're absolutely right. Well, of course, it not only aligns with those dominant social relations, it also makes those dominant social relations possible. So, you can't understand contemporary capitalism or contemporary colonialism, for example, without recognizing the fundamental architecture that is private property and the ownership model more generally. But that said, I think we need to, and this is maybe if we want to go back to Marx and others, we can't just assume that there's an inevitability to the way in which that model came to be. It's a long and ongoing and continuing series of social struggles and forms of resistance, but also mobilization. So the story of land enclosure, for example, which is easy to read retrospectively as something just pre-given and inevitable. That's the way Locke reads it. Even though, of course, he was writing at exactly the moment at which that enclosure was happening. But retrospectively, it's very easy to construct it as a sort of story of inevitability, which is the way kind of law and economics model would read it. This is obviously the way things should be because it's the most effective way of organizing incentives as compared to the so-called tragedy of the commons, which constantly needs to be challenged. But if you actually look at that history more carefully, you'll see the way in which it was highly contingent and not pre-given in any way, but open to contestation and struggle.
Right. So that within the legal scholarship, then that idea that you need to challenge the idea of property, or allow it not to become a neutral, objective background fact, it has become quite important again, I guess, over the past 15 or 20 years. The critical legal scholarship has started to focus on this idea of problematizing property and not allowing it to be presented as this kind of objective, a fact of life or a state of nature, whatever you want to call it. And I know that we've both been interested in our work in that critical legal scholarship coming through the progressive property school
Right.
of thought that's primarily a US based way of thinking about property and property relations. So maybe we could talk a little bit about that. So the dominant model focuses on this idea that property gives you rights to do certain things with your land and gives you certain rights to behave in certain ways towards other people in respect of your property. But the progressive property school focuses on the idea that if you own something, that gives you a responsibility to others, to the broader community, to use that property in a way which allows for collective flourishing, or different values could underpin it. So that's sort of what I take from the progressive property school, is that we need to focus on responsibilities as well as rights. Does that accord with your understanding of that school of thought?
Yeah, to some extent. I mean, it really does develop within the U.S. Academy, and the U.S. Legal Academy is, as I understand it, heavily dominated by a sort of law and economics notion of property. So we should be clear that the progressive property movement, as it were, is really quite small as compared to the dominance of that, the sort of hegemony of that dominant reading of property, which centers private property and presumed benefits that flow from creating well-structured forms of private property incentives. What I understand the progressive property scholarship is doing is to work within the legal academy. So it's basically legal scholars and property theorists trying to unpick the ways in which legal doctrine, particularly in the US, as well as to some extent the sort of history of property in the US, are in fact more commodious, to use that word we used before, than the law and economics model might suggest. That there are loose ends, that there are alternatives to sort of very narrow Blackstonian kind of conception of private property, that you can find judges on occasion saying that, well, maybe the owner doesn't actually have absolute rights to exclude, that there are certain cases. The State v. Shack case, for example, is often cited, in which lawyers try to access agricultural land in order to reach very marginalized farm workers. In that case, the judge actually pushed back against the notion of the sort of bundle of rights, exclusive power kind of notion of the property owner, to say that in certain cases, yeah, we can see that there's a valid reason why the exclusive private property rights, the castle of the private property owner, needs to be opened up to achieve certain social ends. So it's about responsibilities. It's also about the kind of social ends of property more generally, and trying to argue for the alternative possibilities that are actually extant within existing property. So it's not so much an argument as to how property should be, it's an argument as to how property actually is.
Yeah, and that's really important, I think, to recognise that all those values and challenges actually already exist in the legal regimes that we have at the moment. They're just not always articulated very clearly, if at all. And that's the progressive property movement is shining a light on, I think, or offering a way to shine a light on these things, at least.
Yeah, and I mean, I certainly found it useful for me in, because I'm not trained as a property lawyer, so having skilled property lawyers show me the diversity that actually exists within property, I think is powerful and important, and that allows us to kind of push back against or contest a narrow reading of property. So I've been influenced by it. I also have issued a bit of a friendly critique, as it were, of that scholarship, trying to understand the way in which it constructs its argument. And broadly speaking, progressive property relies on a sort of critique as to the reality of property. So this is law and economics says property is this. Progressive property say the reality of property is something different. It's not A, it's something like B. My kind of friendly critique is to say, well, this still assumes that there is a reality to property, that we can actually say that property actually is something, that it has a sort of objective reality. Progressive property scholarship is basically saying you've misread what property actually is. Property looks different to what you think it is, and its ethical commitments are different in reality to what you think the dominant reading actually understands it to be. My critique, I wrote this a few years back in an article, was to worry a little bit about this reality to property by arguing that the reality of property at least is not something that's given, not something that's out there in the world, but rather something that's actually brought into being through various performances. Property in that sense doesn't pre-exist its performances, but gets performed through multiple practices.
What is an example of the way that property is performed rather than created through legal rules?
Well, you can see it in all sorts of contexts, but you can certainly see it when you think about, say, the dominance of the ownership model. So one of the arguments I use in that piece relates to the work of the Peruvian economist Hernando de Soto. And de Soto has made a living by arguing the poor of the South, the global South, in informal settlements need to have their property titled and formalized such that then they can enter into the world of capitalism. They can mobilize those resources and do all the sorts of things that everyone else in the global north is able to do when they have secure title to private property. So he's made a fortune by going around countries and selling things to the World Bank and so on.
Very friendly argument for law and economics type property people.
Exactly. It's yeah, they love it. They love it, and they love it for obvious ideological reasons. And it's been taken up all over the world. It is, however, massively flawed. I mean, if you actually talk to scholars of informal settlements, they say, well, you very often you don't actually need to have formal title in order to mobilize those resources. There's alternative economic systems that exist in informal settlements that allow people, for example, to borrow on the basis of the informal assets that they have. They could transfer interests in informal land or informal buildings rather to others. You don't actually need formal title, and actually, if you have formal title, things actually can go kind of wonky. You can have forms of gentrification, you can have forms of land speculation, things that actually make that inaccessible to the people that really need it, the poor, the precarious, and the marginalized. That doesn't really matter because the way in which this story of De Soto produces aligns with dominant understandings of property effectively makes it true. So it's true insofar as the IMF or the World Bank is concerned, because it's sustained by and helps sustain a whole set of other understandings of property and economics and capitalism and so on. So that's an example of the way in which a certain understanding of property becomes true, as it were, through its performances rather than by virtue of the way in which it conforms to, quote, empirical reality.
I think this is a good place to start talking a bit more about this concept of legal geography. So, you've been one of the people that's been centrally involved in developing this idea of legal geography, which is a useful place to go once you've accepted, as a lawyer, once you've accepted the reality that just looking at legal rules is not going to be enough to tell you what's really going on with property and property relations in the world. You need to start looking more widely at the way that property is being performed. My understanding is that legal geography is interested not just in the legal rules, but also about the places where these activities are being performed. So, this idea of the lawscape or the where of law. So, how, in a legal geographic approach, how would that understand property or property relations in comparison with the purely legal approach that we were just discussing?
Oh, well, it depends on what we mean by the purely legal, but that's another question. I would argue that the legal is actually happening in the where and the now. It's not just, in the minds of the judge or on the pages of the judgment. But yeah, legal geography is exactly what legal geography is open to debate, and I'm not going to prescribe what legal geography is. But for my purposes, at least, it's in part it's an attempt to think about the where of law, to recognize that where law is actually enacted or performed or practiced, including property law and property relations, makes a difference to how those relationships unfold. But it's actually more than that to me. It's also a recognition that legal practice, legal enactments, over and above the kind of particular places in which they are put to work, and often the challenges in moving from abstract notions to very particular lived practices in real places. Over and above that, it's also a recognition of the ways in which legal practice smuggles in or relies upon both implicit and explicit spatial, what we can call spatializations, particular spatial notions, boundaries, territories, scales, zones, and so on. So, for example, if we're thinking about property, and if we're thinking about it in the sense of the kind of Blackstonian or the ownership model that we've talked about, we're already implicitly relying on a set of geographic or spatial notions. So if you asked somebody, if you ask my neighbor, I'm guessing, I haven't asked him this question, but if you ask my neighbor what about property, he would define property according to his relationship to a particular space. He would say, "Oh, this piece of land is my property," right? What he's doing, of course, and a lawyer would say, "Well, no, that's not your property. Your property is a set of relations that you have vis-a-vis others, including non-humans, in regards to the use of some resource. It's not the space; it's the relationship." But already he has reified that property relationship and turned it into a space. And that's not surprising because actually that's implicitly the way in which dominant notions of property encourage us to think about property as if it were a space, as if it were something that you could put a line on the map to separate you from your neighbor. So already we've spatialized in a particular way. We've drawn a line. We've created an inside and an outside. And when you draw a line, that's not just an empty categorical move. It's of foundational importance. The drawing of a line, and we can see this throughout human history, is foundational. It has all sorts of secondary effects that are fundamental. So, a legal geographic understanding, particularly in regards to thinking about property, is in part about place, and yes, thinking about the ways in which, for example, dominant notions of property efface local ecologies or place based understandings that may differ or depart from those dominant notions. But it's also about thinking through the ways in which, for me at least, certain property relations, as it were, are spatialized. For example, through the drawing of lines, through the creation of territories, and the argument is that that's more than additive. It's more than just sort of adding another level to thinking about property. That perhaps it's in some sense important in a more foundational sense. It's transformative. It shapes the way in which we actually begin to think about property, begin to think about what property could be or what property actually is. So it has actually, I would argue, ideological effects that, for example, help naturalize certain notions of property. You can see that if we go back to the history of privatization of land enclosure, for example.
Yeah, so it's a completely different framing of the way that you even think about the types of questions that you can ask, let alone how you might try to answer those questions. Just from the ground up, the underpinnings of it are just, it's like a different operating system that you're working with to try to explore these issues.
I don't cover it like you do as a lawyer, so but I think it does maybe allow us to ask different questions, and it also maybe, in a research sense, asks us to talk to different people or to gather different sorts of data,
Right.
not to give up on absolutely not to give up on, if you will, more doctrinal analysis or more sort of theoretical analyses, but for me directs us to kind of empirical work trying to understand on the ground how property is enacted, practiced, performed, contested, challenged, imagined, reimagined.
I wanted to ask you about some of the concepts that I've come across in the legal geography literature. So within the, maybe we're not calling it a discipline, but within some of the literature, then there are a few concepts that tend to recur that are quite innovative, and for me anyway, were helpful in understanding how to think about these questions in a different way. So the ones I've got noted down here are co-construction. So this idea of co-construction of law and space. So co-construction was one of them. Another one was the concept of the splice. And then the final one, fun one, is nomispheric technicians, which is another idea that kind of crops up. I wonder if you could just, in your words, define what these concepts mean.
The co-construction of law and split and space, yeah. So this is the idea of space and something else, as in constitutive relationship or as co-constructed, is a sort of foundational notion that you'll find within contemporary human geography. And essentially, it's the idea that you can't understand, or it's more helpful to understand a set of social relations, including those associated with law. Law, obviously, for me, is social and political. If we just put it in simple terms, in a sense of a binary for a minute, those social relations produce spaces, but at the same time, the way in which those spatializations are actually constitutive of or help produce the social relations more generally. So law, for example, law obviously produces certain spatial configurations. It creates these bounded spaces of property that we've talked about, which are a very recent idea, of course, if you think about the legal history more generally. The idea of property as something that has a discrete boundary from which others to be separated is not something that's been with us very long. We can see the way in which those have been created, but then we can also think about the ways in which, in so creating those spaces, a set of understandings about subjectivity, about the person, about the ethical dimensions to people's relationship to land, then also feed back and shape law and shape legal practice more generally. So if you draw a line on a map, then the question is, how do you enforce that, for example? Because people then will be worried about people encroaching upon their land. People who were previously understood as commoners are now herding their cattle across what is now imagined as a sharp line in 17th century England. And so law has to change. And so out of that, we get the changes to trespass law, for example. Trespass used to be understood in a much more generalized sense as a wrong done by one against another. A tort becomes reimagined in a much narrower sense as the unjustified incursion or the uninvited incursion of a person into somebody else's land. So we can see there the kind of co-constitution of law and space. But of course, if you think about it, it's actually hard to say, well, that's law and that's space, because they're so kind of commingled and so co-connected. So it's hard for us to distinguish between that which is law and that which is space. Practically speaking, when you think about any kind of given context, it's effectively impossible to disentangle the two. What we're relying on, of course, is an implicit binary that is useful perhaps in helping us think these things through, but isn't particularly useful in understanding the actual co-constitution that's happening in the real world. So consequently, legal geographers have tried to come up with kind of new words to think about the way in which the legal and the spatial are always already entangled in each other and co-constitutive and co-productive. So the notion of the splice is something I just came up with. Splice, of course, implies both space. We have the S and the P of space, and then the law, the L of law. That gives us the notion of a splice, and a splice is then something that is both spatial and legal. So a prison, for example, is legal in that it is associated with criminal law, and people who are found guilty of certain crimes are detained at Her Majesty's pleasure, or they detained by the state for a designated period of time. But a prison only works by virtue of the fact that it has gates and doors and security cameras and so on. It's both spatial and legal. You can't have one without the other. It's, in that sense, a splice. We can take it slightly further, thinking about splicing, so moving away from the noun and recognizing the ongoing performative dimensions to the splice. We need to think about the way in which these splices are actually produced and sustained over time. So a prison only works as a prison if it's performed as a prison by those who are subject to it and those who control it. Thus, we can think of splicing.
And then we were also going to talk about the nomispheric technicians.
Well, the nomispheric technician is a phrase used by David Delaney in his book, in which he talks about nomosphere, and the nomosphere is another way of thinking, if you will, about the splice. Put very simply, there's that which is both spatial and legal, and a nomispheric technician is, of course, somebody whose job it is to produce those splicings, to make those splicings possible. So that could be the lawyer, that could be the prison officer, that could be the judge. Arguably, it could also be the prisoner themselves, because, of course, by conforming to the splice, they also reproduce and sustain that splicing. So the technician refers to those who produce the splice through everyday enactments and practices, as well as, of course, the engineers, the architects, the judges who also make that possible.
Identifying the different technicians is such a great way of reinforcing that idea of the co-construction of law and space. You have to think about how all of these things work together and the impacts that they have on each other. It's never just a
No.
one-way street. So sustainability is a big interest of mine in my research, and a big interest in this podcast series more generally. And one of the themes that both me and the podcast are interested in exploring in our work is the way that sustainability goals, or the likelihood of us achieving our sustainability goals, is in some senses impeded or at least shaped to some extent by the way our property systems are organised. So there's maybe a bit of a standoff there. So, for example, I'm involved in a project at the moment with the Scottish Government looking at the way our property law operates in relation to flats, apartment buildings, so what we call tenements in the Scottish legal terminology, because Scotland, in common with many countries around the world, is trying to improve the energy efficiency of its housing stock in order to meet net zero targets. So, in a lot of places in the world, housing is not particularly inefficient. We use a lot of energy heating homes or cooling homes. And if you're heating a home in Scotland, a lot of the heat is being lost because the buildings are maybe not well designed, not well insulated. So we need to improve the sustainability of our housing, the energy efficiency of our housing. But in actual fact, the property law rules that apply to apartment buildings, tenement buildings in Scotland, make it difficult to do that kind of energy renovation work, because in property law terms, the building as a whole doesn't exist. That the property law only recognises a lot of individual flats that all happen to be kind of piled up on top of one another. But the reality is it's a building, and you need to treat the building as a whole if you're going to improve that energy efficiency. So that's maybe just an example of the way that the legal conception of property runs up against what our sustainability goals are.
Yeah, so I think the example of tenements in Scotland is a really interesting one in terms of the challenges that we face in developing sustainability goals. And perhaps the example that you gave, Frankie, of there is instructive in that legally the tenement is a relationship, as I understand it, or a bundle of relationships associated with a particular type of housing use. But perhaps the people who live in those spaces actually think about property as the space of their unit themselves, which makes it difficult for them to perhaps act collectively and come up with collective forms of relationships and responsibilities that would actually make possible things such as more sustainable forms of energy use.
And I think that's maybe a trend that exists more generally. So I don't know if you saw the recent piece by Brett Christophers, the Uppsala professor of geography, in the New York Times. He was talking about the huge amounts of climate spending, federal public climate spending in the US, which he argued in that piece are going to, what he thinks is going to happen, that it will just support private asset managers. They're going to use this public money to control a greater share of the green energy assets that they already have, as well as the land underneath the assets. The kind of ambitions of the project are being undercut by the way that the property law rules operate to make use of that money. So, so that's maybe more, I think that's like a kind of lawyer perspective on it, perhaps, but thinking like a legal geographer, do you think there's other ways of thinking about the way sustainability and property interact?
I'm really glad you asked me this question because it's one I haven't thought through carefully enough, but it is of fundamental importance. If I think we have to accept that private property and property tropes and understandings more generally, the ownership model being perhaps one shorthand for thinking about this, are fundamental to the architecture of the contemporary social order, which I would describe broadly as one we can think of through the lens of something like racial capitalism. If we accept that, I think as we have to, that architecture is the kind of building blocks for the contemporary social order, and if we accept, as I think we have to, that we have to not only modify that social order but radically transform it to achieve anything close to what we might call sustainability, what we might call climate justice more generally, then clearly we're talking about something of great significance. I mean, the ownership model is fundamental for addressing or not fully addressing a whole bunch of other crises that we confront. Crises associated with housing justice, for example. I've written a little more on this. They're also massively impeded by landlordism, for example, and the way allocation of, say, urban land as well as rural land are organized. So clearly, we're talking about something important. I'm in thinking about the kind of the way in which that architecture, that legal architecture, if you want to call it, creates impediments. Perhaps we want to be thinking about the kind of organizing logics that are at play there, as well as the kind of more formal institutional architecture, the way in which certain people are incentivized to do X and not Y. So I'm, for example, conscious of the power of extractivism. I live in Western Canada, which is in which nature is understood in a highly extractive way as something that should be made available to private actors via state property, that should be made available and to be used as a quote resource, where a resource is understood in a narrow sense as achieving anthropocentric ends, but then also not just the interests of the anthros, but also the interests of private owners more generally. So the oil sands, for example, in Alberta, in Canada, are of fundamental importance to any possibility of achieving some level of climate justice. But a pipeline is being built as I speak, not very far from my house, to facilitate the increased extraction of those resources, which can then be shipped to international markets. Now, to understand that, you have to understand, of course, colonialism, which makes possible the land, turns the what was indigenous relations to land into something that then becomes available for extraction. You have to understand capitalism, but you also have to understand property. So, how is it, for example, that those oil sands can be privatized? Well, because they're understood in Canadian law as state property, crown land, and the crown can then grant leases or grant access to private corporations, energy corporations, who then have a private interest in those lands. They have presumably some sort of lease, which allows them then to extract it, which is then tied, of course, to certain notions of what property should be for. I mean, Locke said, deriving directly from biblical notions. God made the world for men to use and to subdue, and private property is the best way to do that. Yeah, we need to be thinking about that architecture and recognizing the importance of that architecture and what it makes possible, and then also what it effaces, what it ignores, what it denies, what it makes impossible or less possible.
I think we're sort of on the same page there about the idea that property, the dominant model of property at least, doesn't necessarily marry up too well with sustainability goals. But do you feel optimism in a perverse sort of way that the climate emergency that we're facing, or the demands for climate justice that we need to start facing up to immediately, that might be the thing that actually disturbs the model of property that has been so dominant over, the past 40 years or however long?
oh, Frankie, that's the question, isn't it? I mean, at one level, yes, at one level, no. I mean, yes, in that we know that the ownership model is an historical artifact. It's not been with us very long. In fact, if you think about certainly kind of common law notions of property, if that's just our time horizon, but if you think also about other conceptions of property and land relations, indigenous conceptions of relations to land, which go back, of course, millennia, we'd need to recognize that it's just a blip. So at one level we could say, well, it emerged through struggle, and then maybe it can also be contested through struggle and contestation. And it is being contested, of course, we know that. We know that particularly with indigenous land struggles, which push back against that extractive logic and speak to different understandings of land, different relationships to land, in which the land is not a resource, the land is actually an ancestor. It's a relative. So being extractive when it comes to your relative is not a good thing.
That's interesting. That conception of land as being an ancestor, that different conception of property, that would be a good model of property for us to be globally employing at this time of climate justice, you might say, because it would encourage us to formulate our property relations in a different way. So, in your work, you've suggested that it doesn't matter which vision of property is the legally correct vision. What's actually important is which vision of property is felicitous. Could you break that concept down for us?
This is speaking to the progressive property scholarship. I mean, we can argue for alternative visions of property, and we should, but that doesn't mean that they're actually going to be successful. So to think of something a performance as felicitous is to think of it as successful. Hernando de Soto's very narrow understanding of land titling is successful not because it's right, but because it aligns with other performances, what you might call assemblages of property. It plugs very neatly into the operating system of capitalism, racial capitalism, and the incentives that are associated with it. So that becomes challenging then, of course, because just railing against the ownership model, I would argue, is not going to be sufficient in changing the system. Showing alternative conceptions of property, for example, indigenous conceptions of property as more just, as more ecologically just, as more humane, as more intelligent, is vital work. But again, in and of itself, that's perhaps not going to change the operating system. It's vital work, but it's not in and of itself sufficient. We need to be, I think, thinking, if we follow that performative argument, which we don't have to, but if we follow that argument, then perhaps we need to be thinking creatively about actively performing property differently rather than just complaining about it. We can think about, as we can see, the multiple experiments that are happening on the ground, which we don't often see, the multiple experiments that are happening on the ground in which property is being differently performed. For example, indigenous people throughout the world are performing that relationship to property and are doing so often in conscious contestation with those dominant extractive models of property. But we also perhaps need to be thinking about how it is that certain performances become dominant. We need to be thinking about the operating system itself and trying to find ways to understand how that system works, and then and maybe try to change the ways in which performances become successful more generally. So that becomes more systemic rather than simply focusing on a particular conception of property more generally.
Right, so that fits in with the whole legal geography kind of co-production, co-construction idea. It's not going to be enough just to look at the legal rules, or it's not going to be enough just in one instance for a different kind of property performance to take place. Really, you need all of these things to be looked at together and repeatedly so that the model evolves in a holistic sort of a way.
It depends on who you are in this struggle. I come at this as a scholar most immediately, and so you could argue, as scholars, our job is to try and find those alternatives, try and find those different realities, and foreground them. Not simply because that then helps us to push back against the dominant model, but also because it just gives space to that which is being erased by those dominant logics. That to me seems important work. And then finding ways in which we can sort of hold those up, recognize their potential. Land trusts, for example, community land trusts, or radical community land trusts, or indigenous driven forms of land rematriation, all these sorts of things tend not to be seen. But scholars, we have the political capital, the social capital to maybe celebrate and to uplift those struggles.
You and I attended a workshop on concepts of legal geography where there was quite a lively discussion. One of the themes that emerged from the conversation that day was this idea that perhaps legal geography is good at enabling us to unpick problematic conceptions of property, but perhaps legal geography is not the place to look for answers about how things should change or how to make things change. But actually, I think based on what you were just saying there is an important role for scholars, even almost a sort of an activist role for scholars in legal geography, as well as, across the spectrum of disciplines, to uncover different property practices, to highlight different property models, and to use the social capital that we have to kind of get the message out there.
I think legal geography, if it exists as a coherent corpus of scholarship, has been very good at critique. I think that's what drives a lot of the work and drives certainly a lot of my work. So challenging, contesting, denaturalizing in particular by bringing space into the room. I think that's very important. Legal geography is not perhaps good at, although there are some who work in this world, good at making prescriptions within the terms of law more generally, arguing for legal remedies, for example, although there are, I know of colleagues who work in those areas. But I think, yes, you're right. I think geography can be and has been a good tool for uncovering alternative possibilities and trying to find ways in which to hold those up and make those visible within the academy, as well as mobilizing resources, institutional resources, for example, in facilitating those and making those possible. And I think that's important in the sense also in that legal geography, or if I think of my work more particularly, the goal has been to identify people who are not always recognized as having standing in terms of making kind of contributions to social problems, whether they're relating to the climate crisis or housing justice. If we accept that legal spaces are produced through multiple nomospheриc technicians, as we discussed earlier, then we need to recognize that it's not just the experts who produce those spaces, it's also people on the ground. So I've been doing a lot of work with houseless people or people who are precariously housed. And if you try and engage kind of carefully with those folk and spend time with those folk and give them resources such that they can have time with you, they'll tell you all sorts of remarkable things that we didn't know, or I didn't know, about the way in which property law works on the ground, for example, in terms of regulating people's possessions. That's a project I'm working on now. And they'll also have really good ideas for how things could be better. And sometimes those ideas are not, well, we need to change this doctrine, or we need to modify the doctrine of tenure, for example. They'll be maybe more systemic in their direction, but in so doing, of course, they're proposing powerful ideas about how legal space should actually be, rather than how it actually is.
Yeah, so we need to do some more listening as well as all the talking that we normally do.
Yeah, I think you're right. And the question of who we listen to, I think, is important.
Well, I think that's a nice optimistic note, as well as a bit of a call to action to conclude on. So maybe we should wind things up there. Thanks very much for talking to me today, Nick.
Thanks, Frankie. It's been very interesting and stimulating. I'm going to have to think things differently now in all sorts of ways.
That's it for this episode of Landscapes. Thanks for listening. Special thanks to Frankie McCarthy for being the guest host for this episode. And thanks to Nick Blomley again for sitting for the interview. You can find the links and papers that we mentioned in the show notes. You can find a written transcript of the entire episode at adamcalo.substack.com, where you can also get in touch and learn more about land and food issues. This episode of Landscapes was supported by the Radboud Glasgow University Collaboration Fund.